at the end, we have Frida Gardner, who is a consultant clinical psychologist who has worked directly with parents and children, providing assessment and intervention since 1989. She's a senior lecturer at the University of Bristol and consultant, she was senior lecturer at the University of Bristol and is or was consultant clinical psychologist. For Bristol, United Bristol Healthcare NHS Trust. Okay. So Frida opened Orchard House Family Assessment and Intervention Centre in 2005. I visited there, and she's the clinical director of that service. She's currently on a national working party to develop good practice guidelines for the assessment and clinical management of adults suspected of factitious disorder imposed on another. Next to her, we have the Honourable Mr. Justice Kean, who was appointed a High Court judge and assigned to the Family Division in 2013. He is the Family Division Liaison Judge of the Midland Circuit. Next to him, we have Sam King, who is a barrister, and she was appointed as a QC last year. She appears in cases involving children in both the private and public law arenas, and many of her cases feature allegations of domestic abuse. She's also the Equality and Diversity Officer at the Family Law Bar Association. Next to her, we have Olive Craig, who is the legal officer at the charity Rights of Women. Olive delivers legal advice to women on the family law advice lines run by the charity. She also has considerable experience of delivering training on legal issues affecting women to professionals in the violence against women and girls sector. She's a qualified solicitor and has practiced in criminal and family law. She's focused on children law and in particular care proceedings, and she is an accredited member of the Law Society's Children Panel. Getting towards the end now, we have Sarah Parsons, who is Assistant Director at CAFCASS. Sarah leads the private law services in London and both public and private law in East Anglia. She's also the Principal Social Worker for CAFCASS and leads on private law practice development. Before joining CAFCASS, she was a probation officer and court welfare officer, and Sarah leads the CAFCASS group which developed the Child Impact Assessment Framework, which was published last October. And finally, we have Bob Gregg, who is a co-director of Only Mums and Only Dads. This is a registered not-for-profit social enterprise which aims to support parents by helping them make child-focused decisions during divorce and separation. They do this via their 2 websites, a live chat facility, and by distributing professional advice articles via social media. They're helped by their family law panel, which is a network of 160 resolution member solicitors and mediators who offer any parent free information on their legal options. Bob is currently co-editing 101 questions answered about separating with children, together with his colleagues, Rebecca Giraud, how do I pronounce it? Giraud, and child clinical psychologist Dr. Angharad Rudkin from Southampton University. That's going to be on the shelves in January 2019. So with that, I think we have the panel fully introduced, and now I'm going to ask them all to say just one sentence that they've prepared in response to the subject of tonight's discussion, which again is allegations of domestic abuse. Are family courts working for children and families? So perhaps I could start with Frida first, and then we can work down the line.
The first thing that came to my mind was I just wish there was more therapeutic services available for parents and for children when there are allegations of domestic abuse.
I'm just delighted that the family courts and family law is now taking far more seriously the issue of domestic abuse and domestic violence, and particularly so far as I'm concerned, the adverse impact that that has on children, both in the short term and the long term.
I've really got a question. A lot of CAFCASS reports make a distinction between domestic abuse per se and situational violence, and I want to understand why that is and what the implications for children are.
A very short sentence in answer to the question: no, they're not.
Okay, well, I won't seek to answer that question with my statement at the start. The thing I want to say at the start is that these are clearly very complex situations for children, and that's what the task of CAFCASS and the family courts are, is to unpick the children's individual experience without thinking too much about the label that's applied to any particular behaviour. and that it's very important to see the whole child and the whole amount of experience that they're being exposed to, the behaviours that they're being exposed to.
Thank you.
Good evening. I feel like the archetypal dad at handover, running late. 3 things for this evening from my perspective. The time it takes courts to make decisions in this area. The lack of support and advice for parents who have been accused of domestic abuse. And a general third point is the seeming lack of preventative work that we currently see in the UK. There's a final point. I do have a bone to pick with page 34 of this report, which we won't go into now, but it's the bottom of page 34 that I think I would, if I could, like to zoom in on at some point.
Thank you, Bob. Alice, could I ask you to come to the front so that you can grab one of these mics, please? We're going to very quickly move to questions from the floor. We have got some questions that people have sent in. But it would be lovely if we could start off with hands up. Who would like to ask either any individual panel member or all of the panel members a question? Okay, lovely. Yep, could you take the mic over there? Remember to identify yourself just insofar as you're comfortable.
My name is Felicity Kaganus. What I'd like to know is what has prompted Cafcass's changed a harder line and acceptance of the concept of parental alienation?
Well, I would first of all take issue with the fact that there's a harder line. What we've done recently, which has already been referred to, is publish our Child Impact Assessment Framework, which sets out very carefully what our definition of alienation is. And it sets out very carefully as well the concerns about any over-identification of alienation. What that whole framework is about is really referring back to what I've just said at the start in my first comment, that we want to see all the forms of harm to children, whether that be from alienation or domestic abuse or harmful conflicts, all of the other aspects of the things that can happen to them in these situations. So I don't think there is a harder line, and I would recommend that you look at our Child Impact Assessment Framework to see the complexity and the subtlety of that guidance and the extent of the training that's going on to help our practitioners understand the child's individual experience.
Thank you. There's a lady in a red top there, Alice, who has another question. Thank you.
Thanks. Iona Gordon. On that point about parental alienation, what happens if an expert witness is found to be someone who actually helps and supports organisations like Every Parent Matters, Families Need Fathers, and she is then he or she is then the expert witness in a case when it's quite clear from the word go they're supporting the father in the case?
I'm not sure how that directly relates to the domestic abuse agenda here, but perhaps we'll address that question now and then move on to one that's more directly related to the topic under hand.
For myself as well.
Who would you like to direct that question to?
I think Frida.
Oh.
I think it's imperative that expert witnesses remain independent at every level. And it's the duty of the court to ensure that an expert witness is indeed independent. And that should be vigorously tested within the court process.
Perhaps you would like to take that, Mr. Justice Keir?
Yeah, certainly. I mean, if that became apparent, the weight that would be attached to that expert's witness would be virtually nil. And there's a much greater awareness nowadays of the pernicious nature of parental alienation and how it affects not just the relationship of the child with the parent, but for every aspect of the child's functioning and ability to form relationships in the future.
There's a lot of people in the room, so we're going to try and get through more questions. Can people be thinking about questions while I ask one that came in earlier, which was, why are we not using the FDAC model for domestic abuse cases? There would seem to be obvious advantages, such as judicial continuity, intensive support and oversight for the process whereby a victim is attempting to leave. Any of the panel like to take that?
I'm afraid it's down to resources. We are trying to roll out FDACs more widely across the country. Government will provide funding for the first year. Thereafter, it's for the local authority to have to fund it. They are all suffering a huge financial constraints. And so we're having a struggle maintaining the current FDACs that we have, let alone expanding them. Moving over into domestic abuse, I think at the moment would just be unrealistic. It's certainly a goal for the future, but unrealistic at the moment.
Thank you. I'm not sure what's happened to the FDAC National Unit, which I know came under really serious threat a few months ago. Do you know what's happened with that?
I don't.
No. Does anybody here know what's happened to the FDAC National Unit, which looked like it was going to run out of funding with no recourse? Oh, are you saying it's gone? Thank you for that. Very interesting. So no support for the FDAC areas. Great. Question from the audience then. I saw, yes, Alice, would you like to take the mic over?
Hello, my name is Richard Nixon. My question is to the High Court Judge. Your former colleague, Sir James Mumby, in 2014, in response to a question at an annual general meeting of Families Mere Fathers about non-molestation orders, said that wrongly granted ex parte orders set the tone of proceedings. And of course, the data has shown a 30% increase since the changes to LASPO. However, one area we've identified is huge increases in certain courts in the Midlands, where you say you're the 1,000% increase in Derby Family Court, 400% at Birmingham and Wolverhampton. What's going wrong in the Midlands that's seeing those huge, treble and four-figure increases?
Well, unfortunately, I'm afraid I wasn't aware there had been that increase. I don't know what the cause of it is. Sir James issued a practice direction to all judges into how non-molestation orders were to be dealt with. And I'm not entirely convinced that that's being followed either in the Midlands or elsewhere in the country. Because what he was clear about is because of the potential impact of an ex parte without notice non-molestation order being granted right at the beginning of proceedings can adversely affect the conduct of the proceedings, that it was very important that when you made a without notice order, there was a very short period that it lasted before the matter came back to court. And that, I think, it's there where it is falling down. And that arises principally because of the enormous great pressure of work on the family courts, not only on the private field, but also we've seen similar huge increases in the public field. And unfortunately, we haven't seen a corresponding increase in the number of judges available to deal with these cases.
Does that answer you?
Nobody comes up with the solution.
Can I?
Yes, would you like to say something?
Something about that as well, because there has been an increase in recent years in applications for non-molestation orders, which actually only takes the number of applications made back to what it was previously around 2009. And there's nothing to suggest that that increase in applications is a result of false allegations or applications being made maliciously. What's been said is absolutely right. Of course, if an application is made ex parte, it has to come back to court quickly, so that the other side can have their say in relation to the application. But I think it's really important to challenge any idea that any increase in applications for non-molestation orders is a result of increase in false allegations being made.
Does anybody else on the panel want to respond to that question? You have a question? Yes?
I just wanted to...
Oh.
Hello, Angela Roberto. I just wanted to check how you're measuring that the increase in non-moles can not be contributed to false allegations, because as far as I'm aware, nobody's keeping statistics on if allegations going through court are false or true?
No, and that is something that there needs to be a lot of research in relation to lots of different aspects of the family courts and lots of aspects of the way in which the family courts are dealing with domestic abuse. There is a lack of general research in terms of how these allegations are addressed. And obviously from my perspective, I'm worried about that because I see the fact that there are not enough fact-finding hearings. So how are courts then going on to make decisions based on allegations which may or may not have been proven? And how are courts making those decisions when they're not having fact-finding hearings to address those allegations? Is it because judges are taking the view that allegations that are made are not relevant to the outcome of the decision? So I think I would like to see research in terms of how are judges deciding whether or not to have a fact-finding hearing? Is there an issue over they're looking at a list of allegations and they're deciding that those allegations aren't relevant to the welfare of the children, to the welfare decision? So there's no research into lots of different aspects of it, but certainly the figures, although there's been an increase, there's no reason to believe that that's as a result of malicious allegations either.
It's based on hard, raw facts provided by the Ministry of Justice.
Mr. Jack, for 1 minute, that it was right.
A lady over there.
Families Need Fathers got a lot of publicity and papers like the Telegraph and so on for the research that the gentleman on my left has brought here onto the floor. There's actually quite a high standard of evidence that needs to be provided before you get a non-molestation order. The idea that these non-molestation orders are being granted with no evidence and willy-nilly is ridiculous. And this is, it's just not true.
Okay, thank you. Yes?
It's a little bit unusual, but because I'm the camera, but
would you like to put the microphone up to your...
in response to that, because I've written a couple of blogs...
Alice, can you speak into the mic?
I've written a couple of blogs recently for the Transparency Project on exactly that, where I tried to look into it. And obviously, the narrow issue can't hijack the night, and there's important things, but I would echo the fact that there is no research, as far as I can see. There are some important numbers, particularly regional variations, but there's nothing to explain them, and I would really echo what the panellist has said about I didn't find, and I was really open to looking, any evidence that we could make that leap to it being false or abusive allegations. That's not to say it's not, it's just that it's not clear, we don't know. And I'm merely saying, if interested, I'd really encourage you or welcome you to read the two blogs, including one quite recently, which goes into it and has all the links to the research and the Families Need Fathers reports, and the articles in the press that people are referring to. And obviously, there's space for comments, and you're more than welcome to comment on it.
Okay, I think we're going to just move on from this question now. Yep. I know that there's a question from Diana Jordan, who is in the audience. Diana, would you like me to read your question out, or would you like to ask it yourself? Yes, okay. Could you take the mic down there? Oh, you'd like me to read it out? Okay, that's fine. So Diana's question is that CAFCASS, it relates to private law proceedings. CAFCASS, she says, appears to have a policy of contact with father at all costs, ignoring any abuse of mother and or children. The same enthusiasm is not seen for contact with mother when residency is transferred to an abusive father. She says, I'm well aware that there are abusive mothers too, but I can only talk about my experience in practice. Are we allowed to know what CAFCASS's policy is and what guidance or instructions are given to family court advisors about supporting contact with fathers?
Okay, yes, certainly the question about being allowed to know, we clearly want our guidance to be as well known as possible so that when people have an assessment with CAFCASS, they know what to expect. And that's one of the reasons, as I say, we've published our Child Impact Assessment Framework, which makes very clear the points that are being made, that CAFCASS does not have a presumption of contact at all costs. That's absolutely not the case. Clearly, if that is some people's experience, then we need to listen to that and take that on board, and you're more than welcome to contact me afterwards if you feel that is your experience. However, the process is, as many people will be aware, is that CAFCASS undertakes safeguarding checks in every single application made to the family court, that we obtain police checks and local authority checks and undertake risk assessment phone calls with every family. And that one of the key features of that, one of the entire purposes of the Child Arrangements Programme, which we operate and work under, is to identify risks. And if contact is not safe and beneficial for a child, then it's CAFCASS's role to point that out. It's absolutely not the case that we have a contact at all costs policy, and all the training and guidance to CAFCASS staff, there's no inclination of that whatsoever. However, we equally have to work within the law, which the document that we're here to launch today refers to, that if safe and beneficial contact for children is identified and is in their interests, then that's what CAFCASS need to point out too, and work through a case to carefully to get to a point where a child can be enjoying a relationship with both parents if that's the best thing for them.
Thank you. Is that something that Frida looks like she wants to... I don't know if Sam, that's something you might like to comment on as well?
Okay. Could I just say that if a family is asked to embark on a psychological assessment, that similarly psychologists don't have the view that contact with either parent should be at all costs. I think the important point that I'd like to, the point that I'd like to make is that the costs can often be different for the parent and the child. And the cost for the parent can often be incredibly high in terms of psychological cost or risk. But in terms of the child, the costs can be very different. And the psychological costs of a lost parent can be very, very significant, particularly when a child has been aware of and witnessed domestic abuse for long periods. I've seen children who were not granted contact to an abusive parent and ended up idealising that parent. And so for them, they had the complicated and very, very painful journey to make of having to separate out an abusive parent with an idealised parent. And that can have long-term consequences for children. And so for children to maintain contact with a real person with whom they have real experience can often be beneficial for a child throughout their process of healing and recovery.
I'll come to you in a minute, Bob.
I just wanted to say that it's not just a matter of CAFCASS giving advice. Judges make the decisions, magistrates make the decisions, and they do have to operate within a framework and a received wisdom about the benefits of having both parents involved, but also the detriments of having an abusive parent involved. And I think that the courts have to travel quite a difficult journey and tread quite a difficult line in relation to that. And so I echo what Frida says about the, if you like, taking away some of the heat out of the issue of whether the parents can cope with contact and looking at the child's needs first and foremost.
Thank you. Bob, would you like to say something?
Our organisation has the benefit of hearing from both mums and dads. Every day we hear from mums who say the system is biased against them, and dads saying the system is treating them unfairly. Overwhelmingly, the vast majority of emails we get are from dads not having contact with their children who say they're being dealt with grossly unfairly.
Was that something that Mr. Justice Kane wanted to speak to as well? You were not... Yeah.
There are always going to be people in a case where one side or the other is disappointed, or indeed sometimes both are disappointed by the outcome. But the issue of contact is treated very, very seriously by the judges. We do start from a point that if at all possible, even if after parents have separated, it's important that both parents remain involved in their children's lives. That is not the same as saying there must be contact at any cost whatsoever. And that's in large measure because there is a growing and increasing awareness amongst all levels of judiciary, including the magistrates, that the adverse effect upon of having witnessed or observed domestic violence can have a very serious effect upon children. And just one example was a case where the president, in the case of Q&Q, found that there had been domestic violence, considered that there could, in very special circumstances, be contact to the father, but the adverse effect on the mother of having to deal with the father at handovers was so grave that unless a safe place could be found for the father to have contact, which didn't involve the mother, contact would not be in the interests of the children. In that particular case, a safe place for various reasons could not be found, and there was an order made by the president of no contact.
Thank you. I know that there was a lady in black beret over here who wanted to ask a question, and then the gentleman in the front and the lady in the second row. Okay.
Hi, I'm Lisa from Women Against Rape and part of the Support Not Separation Coalition. We're in touch with hundreds of mothers across the country who've had short shrift in the family courts by their accounts. We fear very much that account is not taken of the harm of separating the child from the mother, whereas the witnessing of harm or possible future harm of a child is paramount and put over that. What about the harm to the child with the separation? And we also, our experience is that a lot of the professionals in the family courts are very prejudiced. What can we do about them? You know, we had to fight a judge in a family court who constantly insisted that a man who was in prison for domestic violence had access to the woman, and even breaking his restrictions, you know, for allowing him to come to the court where she was not allowed to be in touch with him. She was not allowed to be in the same city with him because he was so violent. And lastly, what are you going to do about mothers who are poor and cannot represent themselves, cannot get legal aid for one reason or another, are disabled, are immigrant, or just don't get proper representation and can't represent themselves necessarily? Thank you.
Okay, thank you. That's quite a few complex questions, and what I've taken out of that is what can be done if you think that you have a judge or a system that is biased against you, and what can be done when, let's not just say women, let's say people in this situation cannot access legal aid and have no other means of representing themselves because they're not wealthy enough to buy it. Bob first, and then thank you.
I can't answer your direct question, but I do want to answer it with a question. The cases that pass through our inbox, I would say 99% are cases we all recognise. There is 1% of cases where things have just gone horribly wrong and parents are at a complete loss as to what to do. And on the face of it, some wrong decisions have been made along the way. And there doesn't seem to be any system for putting a brake on proceedings as they continue. And from where I'm sat, I can just see cases for men and women just going to end horribly badly because there isn't some kind of escape route from the proceedings they're in.
Thank you. Anybody else on the panel like to address that question?
So certainly it's our experience at Rights of Women as well. I speak to a lot of different women who are going through the family court process, often unrepresented, And there are far too many professionals still within the court process. And I say professionals because it's not just the judges, it's professionals generally, who say quite outrageous things to them about their experiences of abuse and what is expected of them as mothers, failing to take into account the trauma that they have experienced. And that's a really big problem. It requires a cultural shift. And I think it requires actually quite a drastic overhaul of the way we deal with family justice, not just individual allegations and individual cases, but actually the whole system is failing people, families. And I think if I could deal with essentially people who can't afford representation. Obviously, Rights Women do a huge amount of work around legal aid, and it's an absolute shock. It's horrific that people who should, according to what the law actually says, be eligible for legal aid, who are eligible for legal aid, who cannot access legal aid solicitors because there are advice deserts across the country. So even where the law says these people should be eligible for legal aid, they cannot access that representation. And then there are, of course, huge groups of people within the family courts who are no longer eligible for legal aid and who simply should be able to access legal aid. I actually think everybody within children proceedings should be able to access legal aid, whether you are making allegations or accused of allegations or whatever your position is. If you are faced with the family courts and having to deal with family law, which, because it's such a closed system, the general public don't understand the general legal principles, but the government seems to think that they should be able to walk into court and represent themselves. Well, it's a nonsense. Of course they can't. So yes, we need to review legal aid drastically. And the final point, sorry.
That's fine.
Is that even once, let's say we have a system where legal aid is available in the family courts, fantastic, and it's available on much more generous terms in terms of the means assessments. Lawyers themselves need to be better as well. Yeah, we all need to be better at dealing with domestic abuse because there are too many lawyers out there who are practicing in this area and who simply don't get it. So.
Thank you. I will come to people. I know that Frida wants to say something. Would you pass the mic? Thank you. Sorry about this. Pass the mic business.
Could I please address a very small part of your question and comments, and that is the issue of the harm that children suffer when being removed from a parent. And I think that, echoing your view, professionals need to be much better about very carefully assessing future harm to a child when they have experienced domestic abuse. And I've listened to many, many children who've said, "It was terrible. I'm going to try and trust my mother, but I do not want to leave her." But there's a tendency within courts, within the local authorities, and I'm not criticising social workers, they have an incredibly difficult job to do, but there's a sense when a child has been exposed to known risk for a very long period of time that the child must be removed from any further risk. And the resources are then placed in providing foster care often for that child, rather than investing in the parent that is the primary caregiver that would derive very significant benefit very often once there has been a catalyst for some change or the removal of an abuser. And I think that many children are harmed again and again and again by removal when we should be far, far better placed at providing intervention and tolerating some risk.
I just want to note that figures came out earlier this week explaining that the number of children in care has gone up yet again by another 4% on an already unprecedented figure. The numbers I'm given by Directors of Children's Services in terms of what it costs simply for the foster care place every year, let alone the other services, are a minimum of £35,000 for a very simple placement, going up to £200,000 for a complex placement per child per year for just the place. I'm seeing councils' budgets literally imploding upon themselves. It feels to me a little bit like an alligator starting to eat its own tail and arriving at its head and having nowhere left to go. And council budgets are going bust, partly because of children's services having to deal with so many acute cases.
But could I just say to that, Louise, that the large figures that you talk about are often for children who have sustained profound harm while being in the context of an abusive relationship. And the behaviour and functioning of children can be very, very disordered. And it is a great credit to local authorities that they invest in those children. But those children who can remain at home, who really need to find ways, often therapeutically, of keeping them at home.
Okay, there were lots of hands up. Okay, I'm going to go to the gentleman there, then the lady there, then the lady at the back. Thank you.
Thank you. Brian Maloney, Families Need Fathers. I wanted to ask Sarah Parsons of CAFCAS, since 2010, you've referred over 2,600 fathers to domestic violence perpetrator programmes, but you haven't referred a single mother to domestic violence perpetrator programmes. Do you accept that there are violent and abusive mothers, and why do you not have any perpetrator programmes available for them?
No, can you hold on to that mic and the other mic will travel to you?
Okay. Yes, the reason that there have been no referrals to domestic abuse perpetrator programmes by women is because the providers that we commission don't currently have that. We are in the process of commissioning them. It's underway. There will be some available shortly.
Yes, quickly.
You do commission programmes from an organisation called Talk Listen Change in Manchester.
Right.
They also do programmes for women.
Yeah. Okay, so it's a 3-year commissioning cycle, and the need for permission for women is recognised as perpetrators, and that will be, as soon as it's possible to arrange that, those will be available. We've had to do, obviously, a great deal of work to ensure that the provision is at the right level and the right availability across the country, because we're a national service that needs to provide services nationally.
Okay, thank you. The lady in the green top. Yep.
Hi, mine's more of a question about when once a woman has fled a domestic abuse relationship. I'm a survivor. I had representation in court, and then I ran out of money and I represented myself till the case was over. I'm a month out of it, out of the system, family court. And when the situation happened, when I realised I had to represent myself, I was on my own. And it brought into awareness the more women I spoke to who couldn't claim legal aid or weren't able to, had full-time jobs, owned half their houses, just out of the, weren't able to apply because of those things, found themselves stuck in a situation. And I was lucky with me because I could carry on and I could have the energy to represent myself. But it's that feeling of when you're alone, you don't know who to turn to, you don't know where to get information from. There were some women I spoke to who didn't even have an IDFA, didn't know what an IDFA was, didn't know about the Women's Aid phone. There were so many things that they did not know or not told, and had fled without had loads of support in order to flee, but once they did, had nothing. And then they were going through the court system, and it's so draining, and it's a lifelong mental thing that you go through when you're put into this situation. Why is there no support for the situation for women who were who are in the situation that I was in?
Okay, is that your question? Why is there no? Is that a question about why is legal aid being cut, or why is there no other support? Right. Okay. Anybody like to take that question? Yeah.
I would hazard a guess that it's partly to do with resources, but it's also probably overwhelmingly to do with the way in which the system is designed. It's a closed system. It's not designed for people to have support around them, and it kind of goes back a little bit to the initial, or one of the very early questions about FDAC and whether or not the way in which the family justice system is set up to deal with allegations of domestic abuse is really the right approach. I don't think it is. So when we look at things like specialist domestic violence courts available in the criminal justice system, they generally have more positive outcomes for the victims anywhere. They certainly feel that they do, and they have support around them. So why can we not come up with a better system within the family justice system to have a similar kind of idea of a much more holistic approach to not just the victims, but also actually the whole family? And that's a much bigger change, and it's to do with resources.
Were you wanting to say something, Sam?
Well, I mean, I think that you would not be able to find a family law barrister who didn't lament the fact that legal aid has been so restricted over the last few years, and wouldn't like to go back to a system where both parties can be represented, not because we want to, as it were, fill our own coffers, but because on a daily basis you see that injustice happens because people don't know the route map through the system, and that is something that everybody within the system, I hope, laments and hope is working, doing what they can to reverse, because people should not go through the system without support. And there are initiatives like the PSU, like the Bar Pro Bono unit, that tries to fill some of the gaps, and people give their time, I know, for no recompense to help with the situation. But the funding position is flawed now, and people who should be represented are not.
Thank you. So there's... Sorry? Oh, did Mr Justice King? Yes.
Just this. There was a journalist wrote an article in the papers in the last couple of weeks of his experience of sitting in a family court and of watching parents representing themselves coming out of court in a very distressed state or in a confused state. He also was able to sit in on a court hearing where the subject matter was allegations of domestic abuse, and both parents represented themselves. And the time came for the mother to cross-examine, to question the father. And she couldn't formulate a question, and she started explaining what her position was. And the judge very patiently tried to explain that that wasn't the time, but it was to ask questions. And she paused and said, "Well, I wrote my questions down in a statement, but I haven't got it here. Well, can you remember? No, I can't. Do you want to ask any questions? I'm not sure. Do you agree with what the father has said?" Pause, and then, "Yes." And that was the end. And that was absolutely pitiful, because that account given by the journalist, I'm afraid, is the experience of judges up and down the country, when people who are extremely vulnerable are trying to represent themselves and appear in the legal system. There are, as Sam said, some provision made for free legal advice or to have support at court. Those are mere sticking plasters. They are not and nothing like a solution to the current problem.
I'll just add something there. I think the account that the judge has just given is one written by a colleague, Emily Dugan. She works for BuzzFeed UK. She very unusually got permission to report what went on in that hearing, and I spoke to her a little bit afterwards. There is nothing, I think, that is going to illustrate the predicament in which people find themselves in these situations that will do so until the day when we're allowed to film in court, but that'll be a long time coming, except for journalists being able to give a blow-by-blow account in that way that just shows the pitiful inadequacy of the system as it stands now, and the failure of that system to allow robust decisions to be made for children. Frida.
Could I just say that when working with families who have learning difficulties, the issue of capacity is brought up very quickly. And I've always thought, working with families who are victims and perpetrators in domestic abuse cases, there ought to be a concept of emotional capacity that we should assess very early on in court cases, and that should be a card that allows people to have legal aid when they require it, just in a way that we talk about intellectual capacity, cognitive capacity, and I think that's something that we really ought to consider.
I'm going to move on now because there's been a lady who's been waiting for quite a long time in the second row to ask her question.
Thank you. My name's Lucy Whittaker. We've obviously been talking a lot about, the adults involved in family court proceedings. We're talking about professionals, we're talking about parents. But what I want to ask the panel is actually about the child's voice. Now, I repeatedly work in cases where children, rightly or wrongly, are refusing to see the abusive party. But the court system will set sort of things in motion and contact arrangements to say that contact must happen with the abusive partner. I want to know what the position is, or what the panel feel the position is, particularly from CAFCASS and from Frida. That actually, if you've got a child that is saying to you, I do not want to see this father or my mother or father because they're abusive, I remember this awful thing happening, I'm scared, I don't want to see them. How do we protect that voice? How do we make sure that that voice is heard, regardless of all the procedures and risk assessments? What about that voice?
Thank you.
Okay, that's obviously a critical function of CAFCASS, is to make the child's voice sing out in the family court, and to make sure that we are able to have enough depth in our assessments and our interviews and our time with children to be able to advocate for them in a way that's credible and convincing. And one of the things that we're doing at the moment in order to make sure that voice is very audible in the proceedings is to do things like insert the children's actual words or their pictures within our report. That's quite a common practice now, and it's been developed over the last 18 months or so. And we do things like when we're inviting children into our offices to come and see us, we will send them a photograph of the office, say, or we will send them a photograph or a picture of the person they're coming to see. So we're trying to allow them to feel comfortable with what's going to happen to them, explain what's going to happen to them, and so that if they have an experience that they want to tell us about, we're facilitating that. However, there is obviously a great deal of complexity in understanding children's wishes and feelings, and taking there's a difference between their wishes and feelings sometimes and their best interests. And that is something that our family court advisors are alert to and very careful about, trying to describe and make sure that we're giving the children the respect to put their words directly before the court, but at the same time go beyond that and help the court to understand and give some analysis of their best interests.
The child is saying no.
Yeah.
I don't want to go. The court has said this contact arrangement. Every other Saturday, I have to go and visit this parent. I don't mind very much. The court has said that actually, if that is breached, we're back to court again because the contact order has been breached. This child is saying no.
Yeah.
And my experience of that is that mum is petrified that actually she will be hauled back and challenged in court, and even accused of turning the child against the other, which isn't true. You know,
okay.
It's rarely ever true.
So again, that's a complex set of circumstances, and again, referring back to the child impact assessment framework that I've already mentioned, one of the key aspects of that is to help CAFCASS staff unpick with children and families what is the reasons for a children's resistance or refusal. Because there may be a range of reasons. It may be that they're genuinely frightened, and if that's the case and they've had an experience that they're frightened, we absolutely need to recognise that and advocate for that and put that before the court and make sure that the court make a safe order as far as we can, make that advice available to the court. But there could be a range of reasons why they're resisting or refusing, and that's what we need to unpick and put before the court also.
Okay, I think Frida wanted to say something, and then if anybody else on the panel wants to, just let me know.
It's really just to take up the point of the difference between what a child says and considering what is in their best interests. And certainly when I've been involved in cases that you describe, and you know we're all very familiar with them, what I've tried to do is to help the professionals understand that starting contact is a process, not an event. And if a child says, I do not want to see my parent, that's a very painful position for any child to be in. And we have a responsibility to help that child get beyond that position, if at all possible. And children can get beyond that position. They can have letters from an abusive parent apologising for what the child has experienced. There can be a healing process involved in helping a child learn that they can trust a contact with a parent. And I think the difficulty is when there is an order, it is, as you say, a very clear boundary. And actually there perhaps built into the order needs to be a more sensitive process that focuses on what is in the interest of the child, not only on what they say, although we have to acknowledge to that child that we have absolutely listened to what they say, but we want to move beyond that for them and for their future.
Okay, I'll just stop. I know that there's a lady there with red hair who wants to do a quick response, I hope, and then we're going to move on. Yes.
I want to ask if child is constantly abused in a abusive father house and court still forced to send child into abusive father house, how do I have to feel about that? How traumatized child, clearly by doctor's decision, traumatized child have to survive that?
Okay, thank you. Who'd like to respond? If you'd like to, would you like to again, Frida, or Mr. Justice again?
Well, what you're describing is traumatic for the child. If a child is being regularly subjected to further abuse in the context of contact.
To force my child to go into abusive home, which she will be abused again and again and again.
I can add nothing to what I've already said. Perhaps I should pass it to someone else.
I'm afraid the answer is that the court would have to be satisfied that that is in fact what was happening. And that might mean the court hearing evidence from you, from the father, from Cafcass, who've inquired into the matter, for the court to determine where the truth lies. Because unfortunately, in terms of making plans for children and saying where they should live or who they should spend time with, we only do that on the basis of facts. And if the facts aren't agreed, the court has to find what the facts are. So we can't act, we can't make decisions about a child on the basis of what is alleged as opposed to what the court is satisfied is proved. So that's the answer, I'm afraid. It's a very, very difficult position to be in. I entirely understand that.
If it is proved from doctors, from police, from witnesses, a child is abused and this keep happening.
Well, if there is that evidence available, it's a matter of putting the evidence before the court and asking for the court to determine what the facts are. Is this abuse taking place? And if the court's satisfied that it is taking place, what's the consequence and the impact upon what contact there should be, if at all?
Okay, thank you. I think we'll move on. Oof. Okay. Gentleman there, lady there, and then lady over there. Oh, and another one, right.
Thank you. John from another person from Families Need Fathers, and I've got some positive suggestions.
Could you lift the mic up a little bit?
It's John from Families Need Fathers again, and I don't know where this idea was that there should be always, under any circumstances, contact with the father. We are a child welfare organisation. Our niche is to get the children the benefit of both their parents. In this, there is contraindications, and contraindications can clearly be domestic violence and abuse, and we're not in denial about that.
Could you ask a question, please?
Yes. The question I'd like to put is, are there not two ways forward? One is that legal aid should be available, not on the basis of the nature of allegations, but on the basis of the vulnerability of the parents, and that should be the only test. The second one is that legal aid goes to, of course, a parent in conflict with the other parent. We need somebody to have the voice of the child, and the voice of the child, only person there is actually Cafcass. There might be disagreements about how well they do their job, but their job is to advocate for the children, and that needs to be put a much higher profile in cases that are for preference, not adversarial.
Okay, thank you. Bob, do you want to say something? Can you pass the mic back along? Thank you.
Very good points raised in the question. As a layman, I've never understood why cases around domestic abuse and accusations of domestic abuse take so long to sort out. I still can't see why it can't be sorted out in a matter of weeks. Some of these cases go on for years, years and years. I too would say, for the sake of the victim, the perpetrator, the falsely accused and the children, there should be limited legal aid available to all.
Okay, so it's that lady there, Alice, who's got her hand up. Yep, thank you.
I'm Judge Caroline Wright. I sit in the Central Family Court, but I also sit in a criminal court as well in London. And I was very interested in what you were saying about the use of resources in different courts and indeed out of court to resolve these disputes. It seems to me, I mean, looking at allegations of domestic abuse, judges can only try cases on evidence and make findings. One of the advantages in the criminal courts is that those are usually processed, particularly the straightforward ones, fairly quickly. People don't need necessarily representation, certainly the accuser doesn't, and the person who is charged usually gets representation. So it is a way of resolving those issues and can be resolved fairly shortly and speedily. And I just wonder whether we need to try and pool our resources. We have, as everyone was saying at the beginning, very, very limited resources here. But I don't think that we make use of the police enough, of other charities enough, for example, domestic violence charities. I don't think we make enough use of the resources that we do have in order to process these cases. And the point that you just made earlier about these cases taking so long is utterly ridiculous, in the sense that when the cases come to court, the evidence is already there. The issue, I think, in the family courts is that because people are unrepresented, it takes ages and ages. And as Mr. Justice Kean was saying, judges are trying their hardest to help people represent themselves, but judges are not representatives. So I would be interested in what the panel think about using other resources that are available in the limited field that we're in.
Thank you. Any thoughts from the panel on that? Other resources, are they there to be had?
There are other resources, and I'm sure we can do more and keep quite linking up, and the PSU is one avenue to do that, the personal support unit. The other point I was about to make is that I don't believe there's been any the duration of proceedings in private law across the country is actually reducing in the number of weeks it takes to conclude a private law matter. The period of the impact of the LASPO legislation, where there was less representation, the cases took as long prior to that. I'm not sure that the lack of representation is totally the issue. It took a long time before, and it still takes a long time, but actually, it's less than it was.
Okay, Sam, would you like to say something?
Yes, in relation to using the criminal framework and trying to, in some way, import that into the civil framework, there are problems because of the different balance of proof, and so that is problematic. I think one of the log jams in the system is obtaining police disclosure, because that is notoriously difficult. You start the process and then you have to make orders, and you will know how many times police default on disclosure in both public and private law cases. So there is a difficulty in relation to that. And there's also an inbuilt process. If you have a fact-finding hearing, then at the point that that fact-finding hearing stops, the welfare questions start to be engaged with. And there may be some way in which part of the welfare analysis can be started before the facts have actually been found, so that you remove one additional stage, or some of the additional stage that comes post-fact-finding. But apart from that, in terms of trying to compress the process, I'm not sure what can be done. And I think that there is also the difficulty that has been repeated, and that I think we all know working within the system, that the system is pretty threadbare at the moment in terms of resources. Judges are working extraordinarily hard. CAFCAS is doing as much as it can on a very tight budget and with edicts from on high about just how much work can go into individual cases. And so we are left with a system that is straining to deal with a problem that is becoming more overt, although has been part of the process for a long, long time.
Okay, thank you. Now, Alice, can you go to the lady over there in the green top?
Hi, I'm Beth from Mothers Unite. We do support mothers as much as we can. We're not solicitors, so, but in answer to one of the questions that was asked earlier, there is some of that around. The question I ask is, I don't know if you're aware of the three-planet model, where you've got the child protection planet, and you've got the child contact planet, and you've got the domestic violence planet. So what happens is you go to the police, there's been domestic abuse, you go to the police, a crime has taken place, they provide protection and refuge for the mum with the children. Then you go to the child protection planet where children's services get brought in, you're asked to leave the relationship, take the children out of the relationship to protect them. Then you go to court, and then the judges tell you, no, you must put the children in contact with the abusive parent. How do we align that? Because you're getting told different things from different people, and these children are then being taken out of the risk and then being forced to be put back straight into the risk again.
Really interesting question. Mr. Justice Kearn, I think I'll send it straight to you.
I think the answer is this. You have established that there has been domestic abuse between the parents. You then have to consider what impact that has upon the child, and therefore is contact in the best interest, welfare best interest of the child, and in what circumstances could contact take place safely. So it's not a correct formulation to say a child has been taken out of a circumstance of abuse where the mother has to separate from the father and is being put back into it. The child would only be put into contact with the father if it was determined on the facts of the case that the contact was in the welfare best interest of the child and could take place in circumstances which were safe. In determining that, there is always an element that it might be wrong, because judges are only human, and you make the best assessment that you can on the advice that you have available to you and on the evidence. But no judge would, there being proven domestic abuse, order contact to take place in circumstances where the judge was satisfied that there was a substantial risk that the child would be at risk of harm if that contact took place.
Anybody else from the panel on that? No, there's a gentleman in the front who I think wants to ask a question.
Thank you, Matthew Richardson. I'm a practicing barrister, and really picking up on that last point from Mr. Justice Kearn, and maybe it's a question for you and also for Sam. My experience over my decade or so of practice is that in reality, there's a different analysis that's done in a private dispute around contact back to an abusive parent than in a care case. And the starting assumption I always have, because this is how it works, is in a private case, if there's domestic abuse, abusive person's not getting contact. If it's a care case, then actually abusive person's getting contact centre supervised once a week. So are we actually approaching this in different ways depending on what bit of the Children Act we're applying under?
Yes. Yes. Okay. Yes, Sarah first, then Mr. Justice Kearn. Yes.
Yes, I think that we are, in the sense that in a care proceedings, if it's ongoing contact, there are needs around the identity of the child, and that's takes place in a safe format. Private law cases in some ways are much more difficult because there's no team around that child. This is an ongoing situation where there may be no other professional, no other supporter available. So I think there are different circumstances, and that's probably why we approach them differently.
Thank you. You want to move the mic along? Thank you.
I entirely agree. And it's because when you are in a public law case, you have the local authority there that can make provision for supervision, be it in a contact centre or anywhere else. Invariably, in the private law situation, very occasionally CAFCAS is involved, and CAFCAS over a very short period can provide supervision, but it's very, very short term. But in the vast majority of cases, and particularly those parents who are on low incomes or indeed on benefits, there simply isn't the wherewithal to find a safe place for contact to take place. So I don't say that in any way that is a decision that's made on a child-focused basis. It's a matter of resources. And if the resources aren't there and you can't make the provision of contact safe, it can't take place.
Okay, thank you. Lady in the middle with the glasses, and then the lady at the back.
Hello, I'm Joan Connell, I'm a barrister. The Americans run a system called Integrated Domestic Violence Courts. They were started in New York, but then rolled across the whole of the USA. And what happens there is the judge sits in a dual jurisdiction. So the judge sits as a criminal judge, first of all, and hears the criminal matter of the alleged abuse. And then the judge goes on straight away to sit as a family jurisdiction judge and hear issues about contact. What also happens is that at those courts they have people from Women's Aid or the equivalent, and also from housing departments and from benefits departments, all there in the building to be able to give advice. There's then continuity of the judge, and the judge will call the case back in a month's time to see whether the perpetrator is attending probation and maintaining what they are supposed to be doing within the criminal jurisdiction, and also to see whether contact is working. Does the panel agree that there might be a lot that we can learn from other jurisdictions? And I would further add that this was trialled in Croydon about 12 years ago, but they only heard about 5 cases over the course of a year and then decided that it was expensive and wasn't going anywhere. So perhaps would the panel agree that that would be something that we could look at again and look to see whether that might solve some of our problems, particularly with regard to what Her Honour Judge Wright has just said.
Thank you. Who would like to answer that?
Well, I would certainly say that that sounds like a very interesting initiative, and I think the brick wall that you will hit is resources.
Olive?
Yeah, I think my understanding is, and I'm happy to be corrected if I'm wrong, if some of the research into integrated domestic violence courts in America is that they have mixed results in terms of how successful they are, but we can't completely replicate, we can't say that that's exactly what would happen here, because obviously we do have a different system and different attitudes. I think we have to be open to looking at different models, and because the current model is not good enough, and it's letting families, it's certainly letting victims down, it's letting families down. Resources are a big problem in terms of changing, but we're not a poor country. If there was the will within government, then we could make changes, but certainly at the moment there isn't the will.
Okay, Sarah, if you want to answer that quickly, and then I've got lady at the back, Lucy, Claire, and we've only got 7 minutes.
Just very quickly, that I'm aware that the Family Justice Council has proposals before it that they're considering actively at the moment around best practice guidance in domestic abuse courts. So that may be one development that's closer at hand.
Thank you. Yes. Oh, yes. Yes.
Could I just add to that point, Oliver, that I think the system also lets perpetrators down. Because there are a number of times, when I'm assessing a perpetrator, that, what I'm seeing is often a young man who has been subjected to the most horrendous physical abuse often and lived in the most violent of families. And that perpetrators can be extraordinarily vulnerable people who need an awful lot of help in order to achieve rehabilitation. And I know that's not a popular view when we talk about domestic abuse, but those perpetrators go on to form other relationships. And unless we do something to address the issue when these people are children, as they grow up, as they develop, and as they form relationships, we will not have any success in addressing this issue.
Thank you. Lady at the back. Oh, sorry. Do you want to say something quickly? Okay.
Because this goes back to exactly what was said at the start about prevention. We don't do anywhere near enough to prevent domestic abuse happening in the first place.
And in terms of we're seeing the issue as a public health issue is what's really required.
Okay.
Good evening.
I waffle a lot, by the way, just to let you know in advance. But carrying on from her question, carrying on from her question, again, a lot of victims of domestic violence, they go away and they go away and they go into hiding, and then they're brought back into the court system. My question is, they go back into the court system, and then a few things. The perpetrators are given parental responsibility. I mean, practically straight away. On a lot of cases, and then they find out the kid's school, and when contact starts, it goes to close to their area because they can't travel far. I wanted to ask what can be done about keeping children and mothers safe, and how can the court system implement this? Because it is quite unsafe, and then it's having to go through, obviously you've already been through all this abuse, and then going through it all again through the court system. It seems that it's more towards the fathers than it is towards, not even the mothers, the children. And
Okay,
again,
I think we're just getting close to the end, so I think we've got your question. What can be done to keep victims safe?
Well, there are systems to keep victims safe within the court process to some extent, because there are special measures that can be put into place. And I know that there are mixed results in relation to those, and I know that some courts are lack the resources, but there are some ways in which when you're actually face-to-face, as it were, you don't have to be face-to-face. And that, I hope, to some extent, ameliorates some of the difficulties in being in the court process. But of course, it can't prevent the fact that applications can be made, and unless there's a bar on those applications, they have to be heard by the court.
Anybody else would like to answer that? Yes, go
sorry.
on.
Can I? There's some things that could be done to improve the situation right now. I mean, we've talked a little bit about completely remaking the system, but actually, based on the system that we have at the moment, there's a list of things that the government could do. So legal aid, or review of legal aid is one of them. Cross-examination of victims of domestic abuse has to come to an end directly by perpetrators. And the government's been promising for over 2 years to bring it to an end, but hasn't got around to it yet. Increased funding for domestic violence services, and it should be accepted that when somebody comes to court with a Mackenzie friend who is from a domestic violence service, that they will be let into court to act as a Mackenzie friend. Our experience is that they're not always, despite the fact that not being the reality or legal position. And special measures should automatically be available in cases where there is domestic abuse. It's simply not acceptable. I spoke to women this week who had special measures at a fact-finding hearing where findings were made, and she was then not given special measures for any of the other directions hearings after that. It makes no sense. So there's some things that could happen right now.
Okay, thank you. We've got time for probably 2 or 3 more questions. Lucy, Claire, there's been a lady at the back.
Sorry,
Yes.
where was I starting?
No, so we'll start with Lucy at the front. Yes, fine.
I'll just grab this one. I had a question, which actually is a sort of mirror of Matthew Richardson's question about the way we maybe give different expectations to parents who've experienced domestic abuse, depending on whether it's private law proceedings or care proceedings. I recognise what Matthew describes, but the way I'd framed my question was actually the other way around, in that I was going to ask the panel whether they recognise the phenomenon whereby mothers in private law proceedings are expected to co-parent and retain some level of contact and encourage contact, whereas mothers in public law proceedings involving domestic abuse are subject to sometimes more stringent expectations that they must cut off contact, all contact immediately, and if they don't do that and stop all contact, there will be consequences in terms of the removal of their children because it's felt they can't protect. I just wonder whether that's an inconsistency that the panel also recognise.
Okay, who'd like to take it? Yes?
No.
I would certainly mirror that is an inconsistency in terms of the approach of the family courts. It's certainly something that we see from the women that we speak to, and I think you see it as well in some of the case law that comes through. You can see in care proceedings, when you read case law, there are expectations that women will leave abusive partners and end contact, whereas, of course, we know in the private law jurisdiction it's all about co-parenting and trying to be as amicable as possible. So yes, of course.
Sarah?
Yes, I certainly recognise the point that's being made. However, I would say that, repeating what I've already said really, that it's important where possible to ensure children have contact with both parents in private law, because that's the framework we work under, but we are alert to the risks, and so that it's the level of risk that we need to determine. If the level of risk in a private law case is it indicates that it's possible for the child to have a good relationship with the other parent, then that's what we'd be working to. Whereas in the care proceedings, it's already been found, it's already been a sort of a part of the reason why the case is in court, that there are problems in that relationship, and that there needs to be a different approach in that sense.
Okay, could you pass the mic just along, please? Thanks.
I think the other point to make is, in public law proceedings, the circumstances where the issue is solely domestic abuse is extraordinarily rare. There are usually multiple reasons why the father is deemed to be unsafe and the mother is being invited to cease all contact.
Okay, thank you. Can you bring the mic just over here? Thank you. Yes.
Hi, my name is Claire. I'm fortunate enough to be a lawyer, and I have been for 20 years, and I suffer the misfortune of having been in an abusive relationship for almost as long, and having experience of the family court not as a professional. So when I'm asking my questions, I'd like the panel to consider the issues of how Articles 14 and 8 and 6 of the Convention really do sit with what's happening in court today. If a woman or a man is suffering from post-traumatic stress disorder and tries to give their evidence, and Frida Gardner has talked about emotional capacity and the psychological capacity in some of her comments earlier, how does the court view issues where there's sort of the new domestic abuse, which is people are speaking about now in terms of coercion, economic abuse, the non-physical abuses, impact on those parents giving evidence, and how they are viewed by experts? Do experts in court have sufficient understanding yet of the long-term impact of these types of abuse? What guidance do they have?
Thanks. Okay, Frida, would you like to start?
I think the answer is that there is an increasing and growing awareness, and I would not suggest that it is by any means perfect yet. But many more judges now fully understand the impact that domestic abuse can have upon somebody during the course of their evidence. And they, in the majority, bear that very much in mind when weighing up the analysis of the evidence and whether they believe or do not believe one party or the other. More work needs to be done to increase awareness. I entirely accept that. But I believe we have turned a corner, and it is much more readily now taken into account by judges.
I think part of the question was also about experts. Did you want to? Yeah.
I would just agree with what's been said.
Okay. Anybody else wish to respond to that?
Well, I was just, what you were saying brought to mind the analysis that I think is being done by some academics about whether the fact-finding hearing itself is a useful tool in relation to coercive control, and whether, I think it's called an incidence-based, I think Adrienne Barnett's written about this, an incidence-based approach where the judge says, well, just put down the 5 worst incidents or the 5 most recent incidents, and then you're dealing with the sort of slow and erosive, if that's a word, behaviour of somebody. And so those 5 incidents don't adequately capture what's been going on, and they also fail to give the sense of history and the sense of a continuity that may leak into the post-fact-finding stage when welfare becomes the issue and the facts are all found, as it were. Perhaps you would like to...
I would totally agree with that. And I'm aware of Adrienne's work and Rosemary Hunter, and we're working together to make some proposals to the Family Justice Council around the efficacy of fact-finding hearings, in particular around coercive control. And the first, last, most recent is not the most effective approach. And it does leak into the welfare issues in the sense that when CAFCASS subsequently prepare a Section 7 report, courts maybe have found some facts but not others, and that in some ways ties CAFCASS's hands in terms of our risk assessment. So it can be a less than helpful process, and we need to keep working on improving that.
Okay, thank you. We've got time for one more question, and I know that there was that lady with the glasses, her sunglasses on her head, who has been waiting.
My name's Jo Shortland, I'm solicitor. Basically, I was just wondering whether there could be, if the panel thought there could be a triage system, because in a way, the animals going 2 by 2, all cases are treated virtually the same. We have the CAFCASS safeguarding letter, but that is not an effective triage system. So we're having cases that are complex, that coercive control, all dealt with in the same way as other cases where there may have been, I'm not diminishing it, but one incident at the end of a very long relationship. And, you know, when you're screening for mediation, your screening tools that you use will take into account a long-term abuse of a relationship where mediation is completely impractical, and a one-off incident, which is unacceptable, but entirely different. And I just think, you know, you have triage systems in hospitals, you have MARAC for serious cases, and yet, in many ways, they're all treated the same. And I think we're talking about, family courts work in children and families. No, they're not. So, you know, we have to come up with a new system. And, you know, there are very serious cases and there are not so serious cases. And people might find that very unpalatable. But, you know, I think it's very relevant. The other thing I would say is that Sarah Parsons said that, you know, there were, you know, cases, there's no evidence that the cases now that people aren't represented go on any longer. I go to CAB every other week to give free advice. People come in with a sheaf full of orders. They can hardly find the last order. So, and that is not an unusual. And what happens is you'll have a judge giving a final order. It doesn't work. And then there's another application made. And people are back again.
Okay, so I think as that was the last question, who would like to respond to that from the panel? I saw nods and people looking like they did want to say something.
Thanks. The answer is about a different model. There certainly is going to have to be serious consideration given, because Stephen Cobb, of course, Mr. Justice Stephen Cobb was tasked with the private law programme. The President is asking him to look at that again, to see how we can deal with the vast increase in numbers. I've been tasked by the President to look at the public law cases to see what can be done to try and cope with the large volume there. And the sort of idea of a triage system might well, I can't say at the moment it will be, but might well be one answer to try and differentiate between those cases that can be dealt with fairly speedily and those cases which would need much more complex and detailed consideration.
Thank you.
Yes, there are many jurisdictions in the States that use a triage system that we're aware of, and we're looking internationally to find best practice, and a triage approach is something that may well be one of the areas that we pursue.
Olive?
Certainly a triage system is a good idea, but the question that follows that is, what are you triaging them into?
Well, I think, you know, sorry, in civil proceedings, you have fast track cases where issues are getting quite straightforward, and they will be heard, as it says on the label, quicker than more complex cases. And so, you know, it's not easy. I would take it. These are very, very difficult issues. But, you know, that would be something that could be good.
Okay. Anybody else from the panel? Right, I think we are 10 minutes over, so I am going to have to wind us up. I'm sorry, because I know that there are still lots of questions. I've tried to make it so that as many people as possible got one in. I've seen hands creeping up twice as well, and I've ignored them studiously. But thank you all very much indeed for coming tonight. I hope it's been interesting. Thank you so much to our panel. Can we have a quick round of applause for our panel?